Hey everyone, I hope you're doing well and staying safe during this time. If you're new here, welcome to the channel. Like I said, thank you so much for checking me out. If you haven't done so, please make sure to hit that subscribe button just right below the video. Cool, thank you so much. I really do appreciate it. And if you're returning, welcome back. Thanks again for your support. I truly do appreciate having you here.
XRP community member and attorney James Filan has laid out the steps necessary to get court dates set, which will ultimately lead to finality of the SEC versus Ripple law case. And frankly, it was amazing to read through all the specific requirements just to get to the point where a request can even be made to Judge Torres to proceed to summary judgment, which again is the end of the case. That's the part where the winner and loser is ultimately determined unilaterally by the judge. And there are so many things the SEC can do, and likely will, to slow down this case. We're all tired of the seemingly endless headlines and additional delays in the lawsuit, but in addition to official delays granted by the court, there are things the SEC can do procedurally to grind the case to a virtual halt. Attorney John Deaton also shared his thoughts on Attorney Filan's timeline and explanations, and he shares the additional types of information we may be privy to as the general public before the trial actually begins, including evidence that we're currently completely unaware of. He also explains how this will impact how he proceeds with this case, given he's now representing over 66,000 XRP holders. And he also notes that if the normal process that leads to dates being set ends up being waived, which is possible, he will actually have access to less information as a result, and will have to figure out how to proceed, what the path forward would look like in that particular situation. And unfortunately, Attorney Deaton has now come to the conclusion that this case is going to end much later than he hoped. That's his speculation anyway at this point. And I'll share with you when he thinks the case may end and the rationale for his perspective. But even here in the intro of the video, I'll tell you this. Based on what I've read here, I think if there's no settlement between the SEC and Ripple, I don't think this case will end until sometime next year in all probability. That's what it's sounding like at this point. But before going any further, I do want to be clear, I do not have a legal or financial background of any kind. I'm not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. So we'll get going with this here. What's on your screen right now is a thread from Attorney Filan. He is the attorney. I'm sure you're familiar with the name at this point if you've been following this case. He very diligently shares all of the legal filings that have popped up pretty much since the beginning of all of this. And he'll share some thoughts along the way with some specific filings. He doesn't usually share thoughts, I've noticed, this long and in-depth, really breaking stuff down outside of when something's filed. Okay, here's what I think on the topic. So anytime he does, I definitely pay extra close attention, and you're going to find this fascinating. There's all sorts of stuff in here that I was completely unaware of. I've never even seen this discussed, frankly. And so he wrote this out just this morning, and then after this I'm going to get right into what Attorney John Deaton had to say and why he thinks this case, unfortunately, way more likely than not, is going to go much later than expected, and why I'm saying, based on what I'm reading here, looks like probably finality in this case next year, which is not something I enjoy reporting. But anyway, begins as follows. A summary judgment timeline. I'm seeing a lot of discussion of timing projections for the filing of summary judgment motions and a decision on the motions. I thought I would weigh in because Judge Torres has a particular and very complicated process that must be completed before the motions for summary judgment can even be filed. The point of this thread is to help you understand that this is a longer process than you may realize. First, any party that wants to move for summary judgment has to provide the other parties an electronic copy in Microsoft Word format of its statement of material facts pursuant to Local Rule 56.1. A Local Rule 56.1 statement is a, quote, short and concise statement in numbered paragraphs of the material facts as to which the moving party contends there is no genuine issue to be tried, end quote. And then he writes in parentheses, a material fact is one that must be resolved to make a decision on the motions, end parentheses. And then James proceeds. The party moving for summary judgment must at the same time provide the other parties any admissible evidence cited in its Rule 56.1 statement that has not previously been produced during discovery. And they only have to produce evidence that is admissible, so that would not include documents the court previously said the parties did not have to give to the other side. For example, Brad and Chris's personal financial information or the Estabrook notes. Then, the party opposing the motion for summary judgment has to reproduce each entry in the moving party's rule, 56.1 statement, and then write its response directly beneath it. So I'll just pause and note. Realistically, what that means is Ripple is going to try and proceed and get to summary judgment, and it would then be the SEC that would be responding with the comments, their response directly beneath each item. Well, do you think it's going to go the other way? I don't think that the SEC is exactly itching to get this case over with, do you? No. No itch whatsoever. James continues, after that, the party moving for summary judgment has to email and file on the docket for us to see a pre-motion letter to Judge Torres explaining to her the basis for its anticipated motion for summary judgment and attaching the opposing party's response to the Rule 56.1 statement, which will show whether and which material facts the parties agree on. Then the party, I'm sorry, I know this is a lot. This is what I was saying, though. Upon reading this, I was just like, holy crap. It's not as much, I guess it wasn't as much that it was terribly surprising. It's just, given that I don't, and I know most of you also don't have any sort of legal background, to learn the nitty-gritty, all the specifics that must occur procedurally, even to get to a point where we can talk about the end of the case, it was just like, whoa. Anyway, James continues. Then the party opposing summary judgment has to email to Judge Torres and file on the docket a letter explaining why it is opposing the motion. Yes, that would be the SEC, right? After that, Judge Torres will review everything and inform the parties whether a motion for summary judgment is warranted and, if so, set a briefing schedule for the filing of the motions. Only then can the motions be filed. So I haven't even gotten to the point until here, assuming that all goes as cited right there. Then he can file, the motions can be filed. James continues, now the parties are submitting a proposed schedule this Friday, and it's technically possible that the parties will agree to waive the requirements of pre-motion letters and the exchange of Rule 56.1 statements of facts. Let's just pause. It's possible. I don't know what the probability of that is. And when John Deaton hops in and gives a response to this afterwards, it seems like there would be pros and cons, with a pro being maybe it speeds things up at least to some degree, at least in terms of getting dates set. Negative might be that he might have less information available to him. So I'll let him speak for himself when we get to that point. But anyway, James continues again. I have to think that Ripple, Brad, and Chris would want to waive these requirements and will be pushing very hard for a faster schedule. But with the SEC delaying this case at every turn, you really must wonder if the SEC would ever agree to the waiver and make this battle less cumbersome or faster for anyone, even for Judge Torres. Even if the parties agree to waive the requirements, Judge Torres has to agree to that waiver. On top of all this, remember that expert discovery has been reopened until May 13th for the Mets deposition and the filing of the Ripple defendant supplemental rebuttal report. So I'll just pause for those of you that may have missed, and I made a whole video on this, so I'll be brief on this. The Mets report is referencing something that was put together by one Dr. Albert Metz, who was hired by the SEC to prepare a report which purports to prove that the price action of XRP is heavily dependent on Ripple and its success in terms of getting people to and businesses to adopt XRP specifically, which is completely absurd. For anybody that's been in the space for like half a second, if you just look at the very simple data, you can see that the price action of XRP is just following the broader market, which is why there's been no shortage of people that have bemoaned the fact that there's all this good news, especially if people are new to the space and maybe don't understand what's going on or why the markets move. How come there's all this good move? It's a reasonable question. Why all this good news surrounding Ripple and what's happening with XRP? How come none of it moves the price of XRP? How many times have we seen that question by people over the years? Endlessly, right? I've highlighted it again and again and again. So it doesn't it has nothing to do with that. But anyway, there was a supplemental report to this that was filed by the SEC outside of the guidelines that were allowed, and I was kind of surprised that Judge Netburn, I believe it was Judge Netburn, that took a look at the supplemental report and said, hey, this behavior in terms of submitting this, it's outside what is permissible conduct, but I'm going to allow it anyway. That's effectively what was communicated there. I was like, what? So they did something outside the scope of the rules of the court, and you're just going to allow it anyway. I was a little disappointed with that, for sure, but maybe she's trying to make the case as appeal-proof as possible. Maybe that might be what's going on. But anyway, as a result of this, since there's this supplemental report, now we had to reopen the judge actually did this. Reopened expert discovery. So the expert witnesses, Dr. Metz is going to be deposed yet again. All sorts of new expenses are going to be incurred, lawyer fees, all of this, and the SEC is supposed to be paying for all of it allegedly, but that's what's being referenced right there. So we just got news of that the other day. Disappointing, but and yes. Discovery reopened, not fact discovery, but for expert witness, and it is limited just to this, but still, yay, another delay. And in theory, it's not supposed to push back the rest of the dates that have already been set to this point. We'll see. Either way, it just kind of grinds my gears that the SEC got their way on this one. It doesn't seem like they really should have. That doesn't seem like what was right on that. But anyway, attorney filing continues. Also, I expect that the parties will challenge some of the other parties' experts, although I expect that to be a part of the summary judgment process. The amicus briefs also have to be reviewed. The point is that all of this adds to the time it will take for Judge Torres to make a decision because those challenges have to be decided. All of this is very complicated and will be slower than we want. I don't want you to be disappointed when the briefing schedule comes out. I don't think we will see a schedule that contemplates briefing beginning in June. I think that a more realistic timeline for summary judgment motions would be opening briefs in either July or August, and then all briefing completed by either October or November. Now, the issue, and wait till you see what Attorney Deaton has to say. He's a little bit less optimistic than that, actually, it seems, if I understood him correctly. Again, we're almost to a point where he chimes in, but Attorney Filing continues. The issue of the Hinman documents and emails is still being decided, but I think the decision on that would be made while the summary judgment motions are pending, which is why I believe the Ripple defendants have said they are prepared to go forward on summary judgment before that issue is decided. So just pause to note what he's referencing there as far as the Hinman emails. The judge has determined multiple times now that the SEC must produce the 63 emails and 68 draft versions of the Billy Boy Hinman Ethereum free pass speech, has to hand that over to Ripple. And the question mark at this point is, will the SEC end up appealing that decision, because that was made by Judge Knepper, and will that be appealed to Judge Torres? I think the answer is going to be yes. That's going to add even more time to all this. So why is Ripple pushing for summary judgment, finality of this case, if we don't even have that settled? Well, the reason is, by the time we get to the summary judgment, the anticipation is that, or even a date decided, by then the appeal, assuming that it does occur, to Judge Torres, that would have been determined by then. So that's the thinking behind that. That's what we're supposing anyway, which seems perfectly reasonable, because why else? Of course, Ripple would prefer to have that information, as part of their toolkit with all of this. James continues. And for reference, Judge Torres recently issued a summary judgment ruling in a complicated case involving gender discrimination claims against Goldman Sachs. The briefing in that case was completed last November, and the decision was issued in mid-March of this year. The point is, this is a complicated case, and it will continue to take time, more time than we want. Womp womp, yeah. Unfortunately, that does indeed seem to be the case, and Attorney Deaton seems to agree, and he's reflected on the timeline even further, and upon further reflection, you'll see as I go through these comments from Attorney Deaton, he too thinks that it's worse. So again, I don't take pleasure in reporting this, but I'm bringing the news to you. I'm bringing you the thoughts from the attorneys within our community that are speaking publicly on this stuff, and I appreciate their insight. Even if it's bad news, I just want the truth shot straight, just like I'm sure you do. So here's what Attorney Deaton had to say just 5 hours ago today. I've read Jimmy's thread and reviewed Judge Torres' local rules related to summary judgment scheduling. As usual, when Jimmy Filan tweets or speaks, we should listen. Read his thread. The issue right now, as Jimmy points out, is whether the parties have to comply with her normal process. This is important for our amicus brief because if they file pre-motion letters, it will provide us with a lot of information each side is relying on, like evidence, exhibits, deposition testimony, etc. After reading those pre-motion letters, I will know what info to ask to review. If the parties ask and she agrees to waive her normal process and there are no pre-motion letters and the court sets dates, we won't get to see any information until the motions are filed. If that happens, I will have to figure out the best approach to gain access to information. I also remembered there are 16 experts in this case. That guarantees motions to exclude experts entirely or parts of their testimony. We have no idea whether expert deadlines will be before summary judgments or filed simultaneously. Here's the bottom line. We will know more on Friday. Jimmy's thread is 100% on point. Previously, I was asked for best and worst case scenario. I said best case September and worst case late December. After more careful consideration, absent a settlement, best case is late December. So there you go. Attorney Deaton, upon further consideration, thinks the soonest you're going to see full adjudication of this case with summary judgment, meaning the end of this case, the soonest would be late December of this year. So if that's the soonest, is the soonest what's most probable ultimately? I don't know. That's why I was saying I suppose more likely than not. This is why I was saying this in the beginning of the video, and you can see why now. It looks like it's more likely we're not going to see this case over until 2023, which means that it will have gone for over 2 freaking years at that point, and it's only April of 2022 as I record this. Now again, a settlement could occur. I still think that's very possible, in which case we could be doing our happy dances a lot sooner. So I don't rule that out, especially if the Hinman emails, that whole situation, that's appealed to Torres. Torres sticks by Judge Knepper and says, nope, SEC, you've got to hand this over, which is what I would anticipate, and it's what Attorney Deaton thinks is most probable. He's publicly stated that on more than one occasion. If that ends up being the case, settlement might be more likely, but if settlement does not occur, what's most likely in terms of timeline, late December, Attorney Deaton says, which is why I'm saying realistically, probably next year. Yikes.
Posted. I'm your advocate. I'll be back on a daily
basis. I guess I'll wrap up. How can you end it?
Times per day with these videos to keep you updated with everything going on. So, I hope you enjoyed the video. If you haven't done so, make sure to hit that subscribe button. Feel free to share any of my videos with your friends, family, social media, or anybody who may care to listen. Thanks so much for your continued support. I'm always here for you. I want to help you through this time. So thank you so much for continuing to choose me. Enjoy your day, stay safe, and I'll catch you again probably in a couple hours. Thanks, everybody. See you later.